Thank you. Good morning, gentlemen. This hearing is in the matter of case number CFI 57/2021 and is being held by way of video conference before Justice Wayne Martin, appearing from Australia. Any orders made during the course or at the conclusion of this hearing will be made on the registry's instructions by the registry in Dubai. The claimant is represented by BSA Ahmed bin Hazim and Associates. Lead counsel is Mr. Antonios Dimitrakopoulos. The second defendant is represented by Clyde & Co. Lead counsel is Mr. Patrick Dillon Malone. Thank you.
Thank you very much. Mr. Dimitrakopoulos.
Yes, Your Honour, thank you. So hopefully Your Honour has had the opportunity to read through the skeleton arguments. You've read.
I have read all the papers and the skeleton arguments and the affidavits and the documents. So you can take all that as read. Some idea
of the background, right?
Yes.
So
yes.
As Your Honour would have seen, this is of course the claimant's, Mr. KHALED ALMHEIRI's application for an immediate judgment on a claim that we say is very straightforward. It's a straightforward indemnity claim seeking payment under a plainly worded and non-DIFC UAE law governed indemnity agreement for an amount of approximately $30 million, which indemnity agreement was issued by the defendant in these proceedings, Mr. John Cameron. Now, this is a substantial amount, but we say that the issues that Your Honour is presented with are not so complicated, and our submission is that they certainly do not require a trial. In fact, this particular matter is even more straightforward and simple than most claims, say arising from a default on bank loans, for example, and the like, because the only document that is of any real relevance is the indemnity agreement, which the defendant admits having signed. So we don't have here the commonly encountered allegations of forged signatures and forensic evidence or lack of authority that Your Honour may be familiar with in simpler cases. So let me just very quickly go through the facts. So the signing of the indemnity agreement is not in dispute. The indemnity agreement itself, which is in the e-bundle at page 79, obliges the defendant, who is referred to there as the obligor, to indemnify the claimant under certain circumstances that are described as indemnity events at clause 9 on page 88 of the bundle, and which include the claimant's default under a facility document with Qatar National Bank, QNB, a loan essentially for $25 million that the claimant entered into for the benefit of the defendant. There's a short background that led to the indemnity agreement being issued, but we say this is self-explanatory and has only been referred to by way of an introduction to the main issue in dispute, which is the defendant's breach of the indemnity agreement. Now, my learned friend may suggest otherwise, but we say that Your Honour does not need to look at anything before the indemnity agreement was issued. It is simply not relevant to our immediate judgment application. So, in short, the indemnity agreement says, I, the claimant, took a loan out with QNB for your defendant's benefit. So if I default under it, you, the defendant, referred to as the obligor, have to indemnify me under the terms of this indemnity agreement that you issue for me. It is as simple as that.
Sorry, Mr. Dimitrakopoulos, but of course, Mr. Cameron says in his witness statement that there were various statements made to him by an agent of your client, which he says were false. Do you say that I'm not allowed to take those into account at all in assessing whether or not judgment should be entered?
No, Your Honour. When I refer to the factual background, I will deal with those statements.
Yes, all right.
Well, the defences. But
yes, all right. Well,
the factual background.
I'm happy for you to come to those in the order in which you planned. So
thank you.
I'm going to leave it till then.
All right. So the idea here is that the claimant says, I'm doing this for you, so you must ensure that I do not breach the Q&B facility agreement. Otherwise, if I do, you will indemnify me. Now, we will get into the defense shortly, but one point I wish to mention now is that at some stage of the defense to the immediate judgment application, it was actually the defendant himself in his witness statement responding to the immediate judgment application. He said that the Q&B facility agreement was not actually entered into by the claimant for the defendant's benefit. So this you'll find in page 135 of the bundle, is his witness statement. And he says,
so which page number was that?
So
what page
it will
was that
be
again? Page.
The bundle is 135.
135, thank you. Yes, I have it, thank you.
So if Your Honour has that, paragraph 23B,
yes,
Mr. John Cameron, the defendant, says, he actually refers to my witness statement, and he says, similarly, Mr. Dimitrakopoulos asserts that the Q&B facility agreement and the transaction documents were entered into for my benefit. Yet I have denied this, and further I have pleaded that these instruments were for the benefit of other parties, and that this has relevance to the enforceability of the indemnity agreement on the facts of this case. So that's what he said in his witness statement. Now, it appears, I may be contradicted on this, but it appears that my learned friend has not adopted this allegation in his skeleton argument. In any event, it's obviously contradicted by the very text of the indemnity agreement. So if Your Honour wants to visit page 84, we'll find there the indemnity agreement. And clause 4.1 couldn't be clearer. It says, obligor's benefit, obligor is of course the defendant, CAM, that is KHALED ALMHEIRI, is entering into the security term facility agreement and the transaction documents at the request of and for the material benefit of the obligor. So I think this is an open and shut matter. So if Your Honour is happy for me to continue.
Yes, yes, please.
Yeah, okay. So the signing of the indemnity agreement by the defendant is not disputed. The entering of into the Q&B loan by the claimant is not disputed. And it appears that the fact that the claimant did so for the defendant's benefit is also not disputed, at least not that we can see in the skeleton argument. And in any event, even if it is, we say it is clearly contradicted by the wording of the indemnity agreement that we've just had a look at. So just to give Your Honour a flavour of how absolute and uncontroversial the wording of this indemnity agreement is, in case Your Honour has not seen it already, clause 4.3, this is again at page 84, Your Honour can read this, it clearly says that the obligor has either taken or has declined to take appropriate and independent legal and financial advice as to the commercial and legal risks and implications of entering into this agreement. And then it says he has full knowledge of the commercial and legal implications of entering into this agreement and the transactions contemplated, and is willingly entering into this agreement without being unduly influenced by the claimant or any other person. And also a little bit further down on page 88 of the bundle, clause 9.1, if I can take it on there, just a few pages down, page 88.
Yes.
It's clause 9.1, yeah, it says it deals with a key indemnity event and describes this as covering even a breach by the claimant of the Q&B facility agreement or a breach of any of his other obligations. So for all those breaches that the claimant may be exposed to, the defendant agrees to indemnify him. That's all that 9.1 says. Now, the facts that followed after the indemnity agreement was entered into, Your Honour, we have set out a short chronology in our skeleton argument.
Yes.
So that's on page, it's become page 604 now in the bundle. But in short, the claimant did default under the QNB financial agreement. He was then served with a demand letter from QNB. He had one of the security checks, well, the security check that he provided under the QNB loan for about $28 million presented by QNB for encashment. But of course it was dishonored. If I could just briefly take you, Your Honour, to page 249 of the bundle, you will see there the provision in the QNB facility agreement for a security check, if you can see this in the definitions.
Yes, got it, thank you.
And yeah, and then further down in page 316, again, we're still in the QNB facility agreement. There's a list there of checks, if Your Honour can see. Those are not cumulative. One does not add them up. It's just one replaces the other as the interest rises over time. So there's really one security check that the largest amount is 28,359,000 odd. And that exact amount is the check that the claimant gave, which is available on page 115. You'll see a photograph of it, or a scanned copy of it, for the exact amount. It's in favor of Qatar National Bank. This is the check that they presented. And as you can see below, it says, kindly note, we're unable to process the subject check due to the following reason. It's really one reason: insufficient funds. So the check was dishonored. So what the claimant tried to do after that is enter into negotiations with QNB to restructure the facility agreement, as is often the case when there is difficulty in honouring the obligations under agreements like this. So this attempt to restructure was reduced into a document just a couple of pages down on page 117, where QNB writes to the claimant, KHALED ALMHEIRI, and it says essentially, look, at the moment, you actually owe us 30.4 million. And here are some broad parameters of how we can restructure this. But if Your Honour were to go at the end of the letter, page 120, paragraph 6 says, until such time as the necessary restructuring documents are signed by all the parties and the relevant conditions precedent satisfied, the restructuring of the facility shall not be deemed effective. So this was just a general sort of idea as to the framework that any restructuring could possibly take place. It is not a restructuring. So those documents, restructuring documents, and the relevant conditions precedents were never signed. So there's never a restructuring. In the absence of any successful outcome in the restructuring of the QNB facility agreement, the claimant then served the defendant with a letter of demand. That took a couple of years of negotiations until all hope was given up, and the claimant turned to the defendant to invoke that obligation under the indemnity agreement. Now, the defendant failed to respond. He failed to make payment. He even failed to raise any of the allegations that he now raises. So the claimant commenced these proceedings against him. Following which, and during that time, what QNB was doing is it was processing through the Dubai courts to obtain a payment order for the dishonored check. So eventually, the claimant, as he was conducting these proceedings, he was faced with a Dubai court order, payment order, for the amount of the check he issued, which was dishonored, together with a travel ban. That is all available just a couple of pages down, Your Honour, on page 122. 122, you'll see a translation from the Dubai Court Civil Courts of First Instance. It says that the Dubai Court of First Instance ordered to bring the above-mentioned respondent, that is the claimant in these proceedings due to failure to pay the amount of 103 million odd. That is the rough equivalent of the $28 million in dirhams. And there's the Arabic version below that.
Yes.
And further down, there is it's a certificate issued that says that he's failed to pay that. And also it says prohibition. We're now on page 125. Prohibition of traveling and circulating, prohibition to all crossings in the country, and announce the executive document legally. I mean, it's not a brilliant translation, but I think you're on a can see
yes,
the main points. Yeah. So now the reason why we think that the formal demand from QNB is really the only document that is of any direct relevance to our application, notifying the claimant of an event of default, is because that document, the demand from QNB, ties in with the simple wording of clause 9.1 that we just read in the indemnity agreement, that the defendant's obligations to indemnify the claimant in the event the claimant defaults under the QNB facility agreement. So that is exactly the circumstance that clause envisaged. That circumstance being the formal demand letter from QNB. Now, as Your Honour may also be aware, the claimant was provided with a further indemnity agreement by a Mr. Araj, who used to be the first defendant in these proceedings. But, as we have specified in our skeleton argument, neither indemnity agreement was interdependent with the other. Nothing within the text of one indemnity agreement recognizes the existence of the other. No single indemnity agreement was issued on condition that the other indemnity agreement was also issued. In fact, there are no conditions at all, no conditions precedent on either of the two documents. And in general, as we said in our skeleton argument, the two indemnity agreements do not speak to each other. As Your Honour may be aware, Mr. Araj was referred to as D1, defendant 1 in these proceedings, but the claimant opted to enter into a settlement agreement with regard to all issues arising from his indemnity agreement, and essentially replace it with a settlement agreement that the defendant has gone to great lengths in these proceedings in arguing that it somehow is relevant to his defense, and we will come to that. Now, that settlement agreement that the claimant entered into with Mr. Araj, and then he withdrew the proceedings against him from the DFC case, was followed by a breach by Mr. Araj of this settlement agreement. So the claimant commenced separate arbitration proceedings against Mr. Araj because the settlement agreement contained an arbitration clause. So, against this background, and before we move on to the specific defenses raised by the defendant, it is, we say, highly relevant that upon receiving the letter of demand from the claimant back in March 2021, the defendant never responded or reacted in any way, nor does he say in his long witness statement that he responded or reacted in any way. And the first time we see anything submitted on his behalf was when we started proceedings. It may not be a very critical point. However, it is our submission that if a formal demand is made to somebody to pay the very significant amount of $30 million, and he considers that this must be a mistake or a misapprehension on his part, or a breach of a condition on the claimant's part that he understood should normally apply, then one would expect that he would demonstrably express his views in some shape or form shortly after he was served with something that must be a very alarming formal demand. But nothing was heard from him until these proceedings were commenced. And frankly, even then, all that was said by him or on his behalf is a series of allegations that we say do not really amount to anything substantial, And when Your Honour goes through them, Your Honour may see that this is exactly the sort of circumstances that an immediate judgment application was made to address. Now, the reason we say this is threefold. There are three pivotal points to this. We have the absolute wording of the indemnity agreement and the specific clauses that I've taken Your Honour to. We have the fact that nothing which predated the indemnity agreement is reflected in its text as a condition precedent or an assumption other than the claimant entering into the Q&B facility agreements for the defendant's benefit, which is not disputed that he did. And the third point, third pivotal point, is that we have the fact that nothing that post-dated the indemnity agreement altered the level of risk that the defendant assumed in entering into the indemnity agreement in the first place, which risk, Your Honour will recall, it's quite specific, and it's set out in clause 4.3. It says he's fully aware of the commercial legal risks and implications entering into the agreement. He has taken legal advice, or he has refused taking it, and he's fully aware of what he's signing up for. There are some short issues of UAE law regarding the enforceability of the indemnity agreement. Those relate to alleged presumptions and misapprehensions and misrepresentations made allegedly on part of the claimant that we say Your Honour can deal with in the context of this application. Now, before I go into the defences, Your Honour, there's just two fundamental topics that I should raise, but I can skip them if Your Honour does not require me to. The first one is essentially it relates to the court's practice to deal with issues of non-DIFC, particularly UAE law, as part of submissions rather than as points of fact to be testified by an expert witness.
I don't think I need to hear you on that, Mr. Dimitrakopoulos. I'm sorry for calling your name. I'm probably not the first person to have done that. But anyway,
no,
I've
done a very good job.
The practice is to receive it by submission, and I can't see any reason why I would depart from that in this case.
Fine.
So that's a different thing to saying that I think the time is now right for the determination of those issues, which is obviously something I'll be hearing Mr. Dylan Malone on.
Understood, Your Honour. So the second issue, again, you may or may not wish to hear me on, is of course the principles for immediate judgment. No,
I don't need to hear you on that. I've done enough of these cases in both Australia and in Dubai to know what those principles are, and I don't think they're controversial.
Understood. Yes, I don't think that there is any sort of disagreements between the parties on the applicable principles either. So that means I can move on to the defences put forward. Now, as we've set out in our skeleton argument, what we've tried to do is club them into three broad categories. There are allegations of fact. So these are allegations that something happened that presents the defendant, in his view, with a defense. There are allegations of prospective evidence. So here we really just have his suggestion that there may be 13 witnesses that the defendant wishes to call, in addition to expert witnesses on UAE law, which we've covered, and I don't think I need to address you on that. It has been very sort of mildly put forward that there may be a need for UAE law expert evidence. So this is like a prospective evidence. And finally, there are defenses based on the governing UAE law that purport to be relevant to the case at hand and dealing mainly with issues of mistake or misapprehended background to the indemnity agreement, as well as of an alleged time bar. Now, late last night, we received an email from the defendant where he produced some more authorities without any context. So we're only guessing as to what he is trying to say with those. Your Honour will find those in the e-bundle under a separate tab, which is entitled Defendants 22nd of October 2023 Submitted Authorities.
Yes. Yes, I've got those.
So, so we've segregated those at the very bottom, so one can find them easily. I think they all more or less, we have no submissions on those, so I'm sort of the blind leading the blind here, but they seem to be revolving around Article 296 of the UAE Civil Code, which is a very simple article that says you can't really contract out of harmful acts and torts. That's all it says, and we'll get to it. But that's another defense, let's say, another defense that is law-related, applicable law-related. It is a bit odd that the defendant only remembered to submit such a fundamental article late last night, but here we are. We will deal with it nevertheless. So, moving on to the factual defenses. Probably the most dominant one is the Araj settlement agreement. The defendant more or less says that this settlement agreement somehow dilutes any obligation that he has, the defendant, in indemnifying the claimant under the indemnity agreement. Now, there are allegations in my learned friend's skeleton argument of this being a very distinct and complicated factor, or that it is a real issue. I'm using my learned friend's words, but Your Honour will find nothing in the pleadings of my learned friend's skeleton argument that expounds on that. So the unsubstantiated argument being made is that because the claimant entered into the settlement agreement with Mr. Araj, either the indemnity agreement of the defendant is also invalid, or the amount due under the invalidated indemnity agreement of Mr. Araj should be deducted from the amount due under the indemnity agreement with the defendant. That's the submission that's been put forward. The defendant's skeleton argument goes on to allege, Your Honour will find this pretty far down on the e-bundles on page 831. I can just read out very short lines. D2, that's the defendant in these proceedings, yes, entered into the agreement, and he did so on the basis of express assurances and representations that equal and identical guarantees would be entered into by D1, as well as Mr. Al-Amadi. We say he is irrelevant to this application from our end, and on the basis of representations as to the means by which the Q&B loan would be serviced and ultimately repaid in full, as explained further below. Now, what this basically says is, I thought you were going to get another indemnity agreement from Mr. Araj, and that's why I gave you mine. To this we say, there's no evidence of any representations whatsoever. No representations have been shown to have been made. For example, some correspondence to that effect could have easily been included as an exhibit to the defendant's witness statement.
Doesn't Mr. Cameron say that somebody he regarded as the agent of your client made representations to this effect?
Well, okay, then in that case, we have to go back into the principles that I had to bypass, because Your Honour is familiar with that. That you're under no obligation to take this at face value. If
yes, but the evidence isn't contradicted. The evidence isn't contradicted by anybody. So why would I not take it at face value?
I will explain, Your Honour. First of all, it is difficult to contradict the negative. The only way we can contradict it is by simply referring to the text of the indemnity agreement and say that...
Sorry, I don't understand. There's a positive assertion that representations were made by the agent whose name now escapes me that isn't contradicted. I don't see how that's a negative. And I don't see how you can overcome it simply by going to the document, because the case that's put against you is that the misrepresentations had a vitiating effect upon the document.
But this is just a witness statement. And the principles say that...
Well, it's more evidence than you've put on, because your client hasn't sworn a witness statement. Is there a reason for that? The only evidence that I've seen is your evidence, and you can't give evidence of fact. Your evidence wouldn't be admissible at trial.
Okay.
So in order to, you've got to effectively make out your case on either admissions or the documents, because you've got no other evidence. But on the other hand, Mr. Cameron says these statements were made. They're not contradicted by anybody. At trial, of course, Mr. Cameron would be cross-examined and his credibility would be assessed. But on the papers, is there any reason why I shouldn't believe what Mr. Cameron says?
Yes, Your Honour, for the very simple reason that what he says is so fundamental that it would have been included in the indemnity agreement, and it was not. The indemnity agreement would have said.
Comes back to the proposition that if it wasn't in the agreement, it can't have happened. Is that the proposition?
Because it's so fundamental that if it's such a fundamental condition for one to expose himself to an indemnity on such a fundamental precondition or assumption, I think it goes without saying that such a fundamental condition would have been set out clearly in the indemnity agreement, or at least the indemnity agreements would be talking to each other, recognizing the existence of each other, as opposed to being almost intentionally and by consent completely separate and not interdependent of each other. So there's really an intention there to say that even if an indemnity agreement is obtained by somebody else, and even if representations were made that this was going to happen, this has got nothing to do with the liabilities that the defendant accepts to take under his indemnity agreement. So in short, whether representations were made or not is neither here nor there. So it doesn't need to be contradicted. All we need to do is point out that it's just not there in the indemnity agreement. Can I continue?
Yes, yes, please.
Now, there are no other conditions, presumptions, or assumptions subject to which the defendant agreed to enter into the indemnity agreement set out in the text of the indemnity agreement, certainly none of the sort that are now pleaded by the defendant. And we say this is relevant to the extent that the defendant says in paragraph 5C of my learned friend's skeleton that the defendant entered into the agreement on the basis of material representations that turned out to be false. So we say there are no representations made in the indemnity agreement, and hence if no representations are in the indemnity agreement, there can be no misrepresentation that can arise out of it. We say that this is also relevant in paragraph 20, Roman numeral 4 of the defendant's skeleton, which is on page 834.
Yes.
Where he says the claimant cannot resile from his previous promises or otherwise enjoy the commercial benefit he obtained without bearing the burden of the failure of those promises. Now, again, I'm not very clear as what is referred to here because there are no promises on the part of the claimant that were written into the text of the indemnity agreement. So this we say is an irrelevance. And as we've made abundantly clear in our submissions, the only matter that is relevant as far as the whole chapter of the settlement agreement with Mr. Araj is concerned is if any amounts were actually received by the claimant from Mr. Araj in any shape or form, whether under the indemnity agreement or the settlement agreement. And those that have been received have been voluntarily disclosed in a witness statement by the claimant. And Your Honour will find that on page 464 of the bundle. Nobody obliged him to do that. He put out a witness statement and say, look, this is what I've done. I've received just under 2 million. Here's the settlement agreement. Here's what it says. And you'll see, Your Honour, paragraph 9 of page 463. It says, as of today's date, I have only received 1.955 odd million from the first defendant, that's Mr. Araj, pursuant to the terms of the D1 settlement agreement. The first defendant has since defaulted, and then I've started arbitration proceedings, And then in paragraph 11 says, in the unlikely event that more sums are forthcoming, whether voluntarily by the first defendant or by way of a successful enforcement upon him of any future arbitrary award, I shall continue to update the court. So we say there is nothing more that is relevant at this stage other than what we have received. Now, if I could just pause for a moment on this topic, and if we can just cast our minds back to the time before the settlement agreement took place. The reason I want to do this, Your Honor, is just to see the ecosystem that the defendant had accepted to live in at that time and the risks that he willingly took. Just to see if anything changed after the settlement agreement with Mr. Araj was entered into. So given the lack of interdependence between one indemnity agreement and the other, it was always theoretically possible from the defendant's perspective that money could be received under one indemnity agreement, say by Mr. Araj, unbeknownst to the defendant. And he could, in theory, then be faced with a demand by the claimant to pay under his own indemnity agreement. That was always a risk, and it was an accepted risk. So there are no parallel guarantees, as alleged by my learned friend in his skeleton of paragraph 33. There's no parallel. So this is because the two indemnity agreements do not speak to each other. There's nothing in parallel in any sense. And there is no implied term either, which is another allegation made, that another indemnity agreement would of course have been obtained. And no authority to that effect has been presented by the defendant, that such an implied term is the norm. Because such a term would not have been implied because it would have been far too fundamental to not expressly include it in the indemnity agreement. So we say that the risk environment that the defendant had already accepted to face when he issued his indemnity agreement, much before the Araj settlement agreement took place, hasn't changed. So the settlement agreement, which was breached by Mr. Araj, is nothing more than another iteration of the indemnity agreement that Mr. Araj had issued but did not honor. So neither his indemnity agreement nor the settlement agreement is of any concern to the defendant. We say that despite the defendant's effort to pick apart all elements of the settlement agreement, which was disclosed to him, but which does not concern him, the fact remains that nothing with regards to the Araj settlement agreement changed this theoretical risk that he undertook before, and nothing has been demonstrated by the defendant to have exposed him to any greater risk or uncertainty that he had always accepted from the beginning.
Well,
and
sorry, can I just interrupt?
Yeah, sure.
Of course, under English law, if there is more than one guarantor and the party, the beneficiary of the guarantees releases one, then that has implications for the liabilities of the others, whether they're expressed to be interdependent or not, because of course principles of subrogation apply, so that a guarantor who pays then has a right to seek contribution from all of the other guarantors. And so if the party releases, then there are implications. Now, first, I think that raised a question. I understand, of course, that this is not a guarantee, this is an indemnity, but then there are questions as to whether there are similar principles. And of course, the question is not one under English law, the question is one under UAE law. Now, this is a point that's raised by the defendant. Have I missed something in your skeleton dealing with that issue? Or is your case simply put that there is no such principle under UAE law, or is it that because there is no reference in the indemnities one to the other, then nothing that happens under one is of any significance to the other? What is your case on that subject?
Let's just go by the process of elimination first and deal with the legal arguments raised by the defendant. Yes. And yes, as Your Honour pointed out, this is not a guarantee, it's an indemnity. And more importantly, we are not a creditor. We didn't give any money. So there's a fundamental difference there. Oh, incidentally, we're not suggesting that the indemnity agreements, the way they're drafted, entitle us to double recovery.
No, I'm not suggesting that. But when you, I mean, the thing in common is that contracts of guarantee and contracts of indemnity are both contracts of suretyship under English law, as I understand it. And so the question is whether there is a similar principle under UAE law. So you're able to help me on that or not?
I have, yes, I will help Your Honour on that, and I'll point to an authority that clarifies the relevance of this.
All right, whenever you come to that, we'll be fine.
Thank you. So another factual defence is an allegation that appears in paragraph 51 of the defence and 52, that the indemnity agreement is unenforceable due to an alleged lack of specificity over the indemnifiable amount. Now, this we say is simply just not true, because the defence essentially that it didn't become operative due to some lack of precise amount being indemnified. Now, this is obviously not true because, first of all, there's no default condition whatsoever in the indemnity agreement. And secondly, the indemnity agreement itself identifies the debt in very specific terms. If Your Honour turns to page 81, these are the definitions under clause 1.1. If we go right at the bottom, the secure term facility agreement means the secure term facility agreement entered into between the claimant QNB, EVL is a company owned by the claimant, on or about the date, and then further down the very last line, for the aggregate amount of $25 million. So the defendant knew perfectly well that the QNB facility agreement amount was for a capital sum of $25 million. So there's no lack of specificity here. The QNB facility agreement is referred to even by its reference number. If you're on very, very quickly, just visit page 238. That's the beginning of the QNB facility agreement. And right at the bottom, left-hand corner, Your Honour will see the numbers 175287.
Yes.
So that reference is reflected on page 82 of the bundle. We're going back to the indemnity agreement. At the very first line, identifying the security term facility, the reference number expected to be 1752. Okay, so we're definitely talking about the same thing. We're definitely talking about $25 million, and of course that amount is going to increase with any interest. Having dealt with that, I just want to move to a further allegation that the transactional documents referred to in the indemnity agreement were not entered into. And that is in paragraph 54 of the defense and page 39 of the bundle. We say this is all irrelevant because the all-inclusive and sweeping wording of clause 9.1 of the indemnity agreement that we've visited before deals with the key indemnity event, and that is even a breach by the claimant of the QNB facility agreement or a breach of any of his other obligations. So given how open that wording is, whether the transactional documents were entered into or not, is first of all, there's no proof as to whether they have or they haven't. But even if they haven't, that is an eventuality that has been captured by the wording of 9.1 of the indemnity agreement. So whether the transactional documents were entered into or not is neither here nor there. We have another allegation, and that is that the QNB facility agreement proceeds were misappropriated by the claimant and applied by ECL and EVL. Those are two companies owned by the claimant, towards the purchase of the GSS loan and the Odyssey loan. These are all the loan purchasing processes that preceded the indemnity agreement or led up to it. We say that Your Honour does not really need to look at any of this because it's all irrelevant in the light, again, of the clear wording of the indemnity agreement. We have no reference to the exact purpose. Your Honour, are you with me? Hello?
Okay, I think I'm back. Can everybody hear me? Yeah, I'm sorry about that.
Not at all, Your Honour. What happened from my end, incidentally, is that I got a blank screen and I knew I was muted.
Yes.
There was no button for me to unmute the screen.
No, I'm sorry. I'm sure it's all my fault, and I do apologise most profusely. So don't worry about your end. I'm sure it was all me. Now, you were telling me about the loan arrangements, Mr. Dimitri.
Yes. Just the short point is that we're accused of misappropriating the QNB loan proceeds, and that we have not incurred any mitigated or indemnifiable loss in any event for us to claim under the indemnity agreement. Now, to this we say two simple things. There is no reference to the exact purpose of the QNB facility agreement, other than it being for the benefit of the defendant. So to suggest any precise journey that the QNB process have taken, which is not the journey that they should have taken and something else should have happened, all of that is so fundamental that if the parties considered that it would be necessary to set out the exact purpose of that facility agreement, they would have included far more detailed wording than simply saying, oh, this is just for your benefit. And we also have an accusation, let's say, that we've not incurred a loss. There's no reference in the indemnity agreement of any mitigated or indemnifiable loss first being incurred for the indemnity obligation to apply. Of course, this is setting aside the very significant loss that we have incurred with the Dubai court payment order of about 133 million dirhams served on us, as well as a travel ban. Now, my learned friend says in his skeleton that this loss is a result of the dishonored check, not directly linked to the indemnity agreement. So I just want to connect the dots here, if I may. I've taken Your Honour to the specific provisions of the QNB facility agreement that refer to the security check. But the short point is that all this is irrelevant because under clause 7.2 of the indemnity agreement, as well as under clause 2.1, the defendant has to indemnify the claimant also for claims, demands, liabilities, losses, and damages. So not just losses. And such demand has, of course, already been incurred just by QNB writing to the claimant and saying, you've defaulted under the facility agreement. And a liability has also been incurred through the Dubai Court of Payment Order and the travel ban as a result of a default under a security instrument that I have taken Your Honour to, the check, falls squarely under the QNB facility agreement, which was entered into by the claimant for the defendant's benefit, as set out in the indemnity agreement, and for the potential default under which the defendant agreed to indemnify the claimant under the indemnity agreement. So this is the sequence and the relevant loss that has been incurred. So to suggest that the dishonoring of the check has got nothing to do with a default by the defendant under the indemnity agreement is simply wrong. Now, the defendant also says in paragraph 5C of my learned friend skeleton argument that that our claim must fail by reason that is in terms of an agreement to indemnify the claimant for the consequences of his own wrongdoing and breach of legal obligation. Well, as we said in the indemnity agreement, this is all covered by clause 9.1, which says that even in that scenario, defendant has to indemnify. Pretty much everything has been catered for and covered in the indemnity agreement, particularly in clause 9.1. There's really no scenario that has not been covered. Now, if I can just move on to the prospective evidence defenses very, very, very quickly. This is all to do with the suggestion that there may be 13 witnesses that are intended to be called by the defendant, and for that reason, this matter should go to trial. Now, what the defendant has done is he's just named them with their brief capacity, but he's not done much else beyond that. You can see that in his statement. It's on page 146 of the bundle. We can just have a look at how minimalistic. Yeah, it starts off at 100, right at the bottom of 146, where he intends to call even the claimant as a witness. And then Mr. Araj, Mehdi. So, Your Honor will see there that is a very poor explanation as to what is the relevance of these witnesses, what is the evidence that they would give, and how such evidence is going to help him successfully defend the claim in trial. There is authority that has been set out. This is the Korean insurance case, which simply says you've got to do a lot more than just list witnesses. So we say that the mere number of witnesses is simply not capable of, in and of itself, become a compelling reason to have a trial, let alone demonstrate that the defendant's defense has a realistic prospect of success. So with this aside, I don't need to deal with the suggestion that UAE law experts need to be adduced. So I can move on to the defenses that relate to arguments in law.
Yes.
Of course, UAE law, federal UAE law, non-DFC law is the agreed and set out governing law of the indemnity agreement. Now, what we say appears to have taken place is that the defendant has gone through a trawl through of all the possible provisions of the UAE Civil Code in the hope of finding something that sticks. And the reason we say that is because in an agreement that has been so carefully drafted, it would be rather unusual in our submission to have what appears to be, as I said, a carefully drafted document, falling foul of so many provisions of UAE law as the ones listed by the defendant. And we say, out of all those, perhaps the least credible one is that there's an allegation that this is a crucial defense for the defendant. Article 1092, that in the opinion of this is of the UAE Civil Code, that in the opinion of the defendant offers him with a time-barred defense. Now, Article 1092 we can find on page 799 of the bundle. I believe it's 799. Maybe that's a commentary. Apologies, Your Honor, I don't think that's the right reference. 1092, there we are. No, so there we are. It's 821.
Yeah.
821. So if a debt is due, the creditor must claim for it within 6 months from the date on which it fell due. Otherwise, the surety shall be deemed to have been discharged from the suretyship. So this is under the chapter of suretyship. And talks about a 6 month time bar applying to the creditor. Now, the reason we say that, before we get into the meaning of that article, the reason why we say this is the least credible UAE law defense is because if a time bar defense were at all available, we say that the obvious way to produce this as a defense is by seeking a strikeout of our claim under Part 24, or seek for the defendant to seek itself an immediate judgment against the claimant, rather than have this sort of provision buried in a collection of what we say are hopeless defenses. But the defendant has not applied for the claim to be struck out, which to us means that he may have less than the complete confidence in his own view as to whether the claimant's claim is time barred or not. But regardless of that, let's move on to Article 1092. This is an irrelevant time bar defense because it applies to a completely different set of circumstances where the agreement is one of guarantee, where the creditor, unable to secure satisfaction of the debt from the debtor, has a direct cause of action under a guarantee against the guarantor. So it requires a tripartite relationship. The indemnity agreement in this instance is obviously not an agreement giving the creditor, there's only one creditor here, that's QNB, any direct cause against the defendant. What we have is a completely different scenario where QNB seeks to recover the debt from the claimant as the debtor, and the claimant seeks indemnity from the obligor under a completely separate and independent contractual document, the indemnity agreement, to which the creditor, QNB, has no relation or access. Now, all of this is not me saying it. There is legal authority that stipulates exactly what the parameters are, and also, more importantly, to close this topic, explains that this 6-month bar provision, 6 months time bar provision set out in Article 1092 can be contracted out of. And it has, of course, been contracted out of. I'll take you to the legal authority, but if I could just refer Your Honour to clause 2.3 of the, I'll just read it out for Your Honour. It says, of the indemnity agreement, obligation to make payment upon demand, on and at any time after, the occurrence of an indemnity event, as defined in clause 9 hereof, the claimant, CAM, KHALED ALMHEIRI, may, by notice to the obligor, demand payment of all amounts due and payable by the obligor to KHALED ALMHEIRI under this agreement. So, let's go to page 825 first of all to just clear the authority on that. So 825 of the hearing bundle, there is a decision by the Dubai courts, Dubai Court of Cassation, 73 of 2020, so it's a recent one. It gives some factual background. It's all a factual background of the tripartite relationship that I've explained. But more importantly, on page 825, right at the bottom, it says this rule stipulated in Article 1092 on the exit of the guarantor from the guarantee if the creditor did not claim the guaranteed debt within 6 months from the date of its entitlement was not related to the public order, but to the private interest of the guarantor. Therefore, it was permissible to agree to violate it with the guarantor's agreement on the basis that the guarantee was a commitment that followed the original obligation and it revolved around existence and non-existence. So it's a slightly convoluted sentence, but the long and the short of it is that this 6 month time bar is not the be all and end all. Parties can agree to it, but if they haven't, there's a default time bar. Again, if we're talking about the tripartite relationship, which we don't have here, the indemnity agreement has got heart and lungs of its own, we say. And the entire provision here doesn't even apply. But even if it were to apply, there's no time bar that comes out of it because the text of the indemnity agreement has contracted out of it. So the next suggestion made by the defendant is that he made a mistake. And he relies on Article 194 of the Civil Code. unless I get the reference wrong again, that should be page 780. That's not 780. So 194 is actually on 802. Your Honor can see that article. If there is a mistake as to the identity of the contract, or as to one of the conditions of the concluding thereof, or as to the subject matter of the contract shall be void. So the defendant has invested a lot in that, and he says that he misapprehended the factual background relevant to the indemnity agreement. So I think Your Honor would probably have his own views as to how believable such a statement would be. We say it is not believable, but the short point is that we also say it is not relevant. Again, thanks to the wording of the indemnity agreement, which in clear terms says what undertakings the defendant made and how consciously he did so, having confirmed in writing that he obtained legal advice, that he is fully aware of everything. It's really an absolute wording that leaves no margin for misapprehension. So if there were any assumptions or presumptions or conditions that the defendant mistakenly thought would or should apply to him for him to issue the indemnity agreement in favor of the claimant, then he should have either included these in the indemnity agreement, or he should have not signed something that says, I understand everything, I got legal advice, I'm fully aware of all commercial risks, I've done it all. But he remained entirely silent, incidentally, after a formal demand was served upon him until the issuance of these proceedings, which again, we say is relevant, because if you're really mistaken and misapprehended something, one would have expected some sort of a reaction, even if it is a dismissive email that says, I owe you nothing, or you have cheated and you have misled me. Something like that, one would have expected that the defendant would have made, but we haven't heard anything from him until we started these proceedings. He just kept silent. So we say this reference to Article 194 of the US Civil Code on mistake is probably a mistake itself, and it's in any event not credible. To assist with this, Your Honour, there is actually well-established authority, not specifically on Article 194, but on the general point of accepting this type of evidence. Your Honour will be familiar with the estate of Christos Papadopoulos and Standard Chartered Bank, which set out that the court is not bound to take everything a party says in its witness evidence at face value, and without analysis, factual assertions may have no real substance, particularly where they're contradicted by contemporaneous documents. And this is exactly our position here. We have a factual assertion, I made a mistake, I misunderstood, I misapprehended, and that is contradicted by a contemporaneous document that says, I understand everything, I got legal advice, I'm fully aware of all the commercial and legal risks I'm taking. So for the defendant to break his long silence since the claimant made a formal demand on him back in March 2021, only to say, I misapprehended, in the face of clear and contradictory wording in the indemnity agreement that confirms expressly the absence of any misapprehension, is, we say, a statement without substance. So at the last minute, as I mentioned a while ago, last night, the defendant submitted further authorities, even though there does not appear to be a corresponding argument pleading what such authorities are supposed to support. Be that as it may, I'm sure my learned friend will enlighten Your Honour on that, but they seem to pivot, as I mentioned, around Article 296. We've set it out in the bundle. It is code. It will be So Article 296 is on page 1008, 1008. It's actually, if one scrolls further down to 1009.
Yes, I've got it. Thank you.
You've got it. It's just one line. It says, any condition exonerating from tort liability shall be deemed null and void. Now, some translations say a harmful act, but I think the meaning is the same. These are acts that would render anyone liable, irrespective of any clause in any contract. Those acts cannot, of course, be excluded, and there's no wording to that effect in the indemnity agreement. Words like, for example, in 9.1, we would have expected to see words that even if such a breach is due to an act of fraud or negligence or tort or wrongdoing or harmful act, for example, those would be the words that are needed to invalidate at least clause 9.1. Those words are simply not there. All we have here is an indemnity for a breach of contract, the Q&B loan. Not an indemnity for committing an Article 296 Act. So anyway, the defendant never pleaded that any harmful act, as in a tort, was committed by the claimant. He never argued fraud or gross negligence or anything that would amount to a liability for the claimant irrespective of any contractual setting. He also never sought through his numerous requests for information, RFIs, that I'll briefly come into those. He never requested any evidence that could arguably corroborate his allegation, which he hasn't even made, of fraud or tort. And we say that the starting point for this, whatever all these authorities submitted last night are supposed to mean, the starting point must be the Q&B demand letter at page 111. All that says is it's not a very good copy, but it's legible. 111. So if you're on a very briefly skim reads through that, it just gives a factual background. This was the loan you entered into with us. You failed to make any payments. The principal amount is 29.7 million. And we've made this demand on you. And then at clause 7, it just lists of all the payments that the claimant failed to make. He says, you failed to pay the loan, you failed to pay interest, you failed to pay legal costs, you're in breach of the facility agreement because you failed to pay legal fees, and then you agreed that the borrower shall, within so many business days of your failure to pay any amount. These amount to $4,000, that's not a big amount, and without prejudice to the foregoing, if the amount outstanding is not paid within 5 business days, Q&B will, without further notice and pursuant to clause 20.16 of the facility agreement, exercise direct CBI to exercise any of all rights, cash a security check, well, they tried that, take any other form of legal action whatsoever, and it reserves the right to make any other form of legal action. So all that says is that the claimant failed to make numerous payments. There's no allegation of an act that falls within the ambit of Article 296. And it's not for the defendant to now, as in last night, seek to invent this, if that is the intention behind the provision of Article 296. The other authorities submitted are either irrelevant or revolve around establishing this allegation of a tortious act, which was not even made and has still not been made. So if the attempt being made here is to seek nullification of clause 9.1 of the indemnity agreement, we say that this must firstly not be allowed at this stage, and secondly must fail in any event. Again, the authorities that suggest that mere statements should not be accepted at face value must be relevant here. So a mere statement that some harmful act has been committed should not be taken into account because it's contradicted by what Q&B said. And it's for Q&B to determine whether a harmful act has been committed. that is in breach of the Q&B loan. It's not for the defendant to invent this or argue it. I just want to briefly touch upon the request for information, simply because they've been focused on by the defendant. So what happened is that there were about 39 requests for information made by the defendant at a stage before the immediate judgment application was made. We responded to all of them and gave documents wherever we felt that we could and we should, and they were available and they were relevant to our claim. This is available at page 384, if Your Honor wants to just very quickly see the format. There is a table at some point that starts at page 391. So that deals with the 39 requests one by one. Now, we did that irrespective of the fact that those requests for information are not reasonable. They're not relevant to the plain, simple fact that the defendant defaulted on the indemnity agreement, and nothing turns on them, and nothing has been, we say, convincingly asserted as turning on them. So, Your Honor, I'd like to conclude and then deal with any questions Your Honor may have. We say that all we have here is the defendant's attempt to convolute and complicate a very simple issue giving rise to this application. And that despite his efforts, he presented this court with no evidence that he has a real prospect of successfully defending the claim. He made irrelevant, unprovable, unarguable, unconvincing, and incorrect allegations. There is no other compelling reason why the case should be disposed of at trial. And we say that the court can safely determine that the indemnity agreement is clearly worded, expressed, and entered into freely by the defendant with a full knowledge of its implications, all expressly set out within its text. And so we say that it's time to bring this case to an end. We request that judgment be issued to the defendant to perform his obligation as he undertook it in the indemnity agreement and pay the claimant the demanded amount. And we also seek costs for the entire proceedings after this matter was transferred to the Part 7 process, to be assessed, of course, if not agreed. So unless Your Honor has any questions, I think these are the main areas I wish to cover.
No, I have no questions. Thank you, Mr. Dimitropoulos. I understand the argument. Mr. Dylan Malone. You're still on mute.
If it please the court, thank you, Justice Martin. If I might start with some general overview comments, and then I have prepared a number of areas where the court may indicate to me that perhaps it's not necessary to address them, or I can address you on all of them. But before I get to those identified areas, if I could just start by observing on behalf of my client that this is a breathtakingly high-wire application that was brought on the eve of a CMC in which the parties were about to transfer or move towards the evidential phase in these proceedings. In our submission, this is manifestly a case where the evidential stage involving, first of all, the completion, we still have to complete the pleadings, and I'll come back to the answers to the RFI presently. Obviously, it doesn't work the way that Mr. Dimitropoulos has urged on the court. You can't just slam down a number of answers in a table, most of which say, I'm not providing you with that information because you reneged on the agreement. But that's the issue before the court, is whether indeed we are in breach or whether we're obliged to indemnify. And they are plainly inadequate, those answers, so the pleadings are not closed. And we're entitled to an adjudication of those matters. And that in itself is already an obstacle to the granting immediate judgment in this case. But more generally, the proposition that is being brought to the court is based upon one side's case. It ignores the pleadings. It is simply a focus on the claimants urging that the indemnity agreement alone is the sole issue for determination, or the sole matrix for the determination of the claim in these proceedings. There's no account taken of the law either, because as has been explained in our skeleton argument, and indeed in the pleadings, and in the supported by the witness statement of my client, there are a number of surrounding circumstances here which UAE law allows and provides for as a potential defense to these proceedings. It's not that we picked those provisions out and then sort of fabricated facts around them. It's the contrary. My client has presented evidence before this court that there were representations made. There was a fundamental substratum and context for this indemnity agreement that was, I'm sorry, this seems to be a call. I'll just get rid of that. That there was a substratum and context for the parties entering into these indemnity agreements, and that failed. And UAE law allows for evidence of those extrinsic matters. I think, Justice Martin, you may be, can you hear me good?
Yes.
UAE law allows for those. So it's not that we've picked out a number of articles that in some way lead to the nullity of the agreement itself. Yes, certain arguments relate to the nullity, but the code provisions that we rely on more generally support the existence of defenses on our case arising from the facts. I'll come back to the evidential position in a minute. The third thing, apart from the pleadings and the law that Mr. Dimitrakopoulos' proposition ignores, is the rights of defense underpinning the proper process of this court in arriving at the truth through an evidential and trial phase as the ordinary process of our system of justice. And here we have an invitation to declare the battle over before it's even begun, in circumstances where the Part 24 procedure is just clearly inappropriate. The assertions that are made of irrelevance and the sole tunnel vision focus on the actual terms of the agreement ignore the pleaded case of my client. And coming back to the RFIs, it's the declamatory refusals and the grounds of refusals for providing information to our reasonable requests for information are effectively repeated time after time after time. You reneged on the agreement, therefore we're not providing it to you. As I said, it doesn't work that way. If I could turn to the claimant's skeleton, perhaps I could just address you again very briefly on the evidential issue. Your Lordship has already indicated and anticipated my point that there has been no evidence from the claimant, whereas there has been, of course, a 20-page written statement from my client. Yet, there are suggestions in the skeleton arguments and in all three of the witness statements of Mr. Dimitrakopoulos, but particularly the last fifth one. There are suggestions that my client is being disingenuous, that my client is not credible. There are a number of allegations today, or suggestions, excuse me, on the submissions of my friend that my client is not credible. And that in itself should raise, of course, a benchmark for you as the court, that how are you supposed to adjudicate today on those questions of credibility, the suggestion that my client is being disingenuous. My client has supported the truth of the matters pleaded, and the suggestion based on Korea National and Alliance is incorrect. If I could bring you quickly to that, it's worth a look at page 775 of the bundle. This is the judgment of Lord Justice Moore-Bick. Just go to paragraph 11 of that. The paragraph relied on by the claimant is paragraph 14. We'll come to that in a minute. But you'll see in terms at paragraph 11, one feature of this case is that Allianz has filed no evidence in opposition to the Part 24 application. So that was a different case, obviously. My client has sworn evidence and has stood up the case, and we've made the case that the particulars of misrepresentation in particular that we have relied on are meet the standard of pleading before this court, and no point has been advanced other than what is being stated in the skeleton argument and the application, which we say is not sufficient. We clearly have met the requirements of pleading, that they should be concise and as brief as possible according to RDC 17.36, and indeed the requirements of, or the standard of, as identified by Chief Justice Wang in the DR case, citing Lord Hope, and that's at page 963 to 964. So the reliance on Korea National, and I don't disagree with paragraph 14 of that judgment. In the present case, Allianz criticised the judge for having to fail to make allowance in its favour of the likelihood that additional evidence relating to various aspects would be available at trial. And this is the part that my friend relies on. It is incumbent on a party responding to an application for summary judgment to put forward sufficient evidence to satisfy the court that it has a real prospect of succeeding at trial. Now, obviously, this is said in the context of a case in which the respondent had chosen not to do so and to rely entirely on the pleadings. In our case, we have Mr. Cameron's detailed statement, which, as the court has observed, is the only evidence that is admissible ultimately at trial before this court. So the net position in my respectful submission is that the claimant is asking this court to disregard the sworn evidence of my client and to look solely at the documents. And again, Justice Martin, you've anticipated that by saying that necessarily in the absence of evidence supporting the application, it must succeed either on the documents themselves or by way of admission. I'll come back to one particular point on admission in a minute when we look at the pleadings. But immediately when one thinks of on the documents themselves in this particular case, it is central to my client's case that the documents alone are not the full picture. So that is the fundamental point that requires this case to advance to an evidential stage. Not just that my client will not be in a position to provide evidence in detail to support the pleading that he has stood up, but also that there will be an opportunity for disclosure, particularly in relation to the transaction documents and how they failed and how they were not implemented and put in place. Just in relation to the pleadings, I think it might be useful if I could just sort of map out where I'm going now. I think it's useful, even though I understand that the case is made against us, that there is a liability to indemnify the claimant because of, first of all, an event of default, and secondly, because of an alleged breach of the agreement. Now, I want to take the second one, even though, of course, to succeed, you can succeed on either one, because I think it's interesting to trace that through the pleadings, to just demonstrate a good illustration of the wider issues that are raised in this case. And the first document I want to take you to is the original particulars of claim. And if I could refer you to paragraph 38 of the original particulars of claim, that's at page 13 to 14 of the bundle. And you'll see under the heading, breach of indemnity agreements by the first and second defendants, the particulars of breach of the indemnity agreement that are alleged against the parties. And you'll see that, first of all, you've got A and B predicated on directors of Odyssey. And then C is an allegation against the first defendant, and you'll see there are detailed allegations of how, in breach of the indemnity agreement, the first defendant brought about effectively the collapse of the funding arrangement that was designed to be put in place for the QNB loan. And then you've got, again, at D over the page, the first defendant neglected or avoided the obligation to ensure that GSS paid EVL, and that's in relation to the asset lease agreement. And then the first defendant, instead, by the neglect set out above, caused the QNB facility agreement to fall into default, and for default fees to be incurred by the claimant. So there's a limited allegation against my client, but also, interestingly, quite a lot of detail about what wrongdoing was originally alleged against the first defendant, which gives you flavour of where responsibility may lie on a full inquiry in this case for the what I call collapse of the substratum of the agreement. And then if we go to page 25 of the bundle, you'll see the amended allegations against my client, which is paragraph 49. So here you again have both of these allegations predicated and alleged qua director of Odyssey, as a director of Odyssey. Now, we go to the defense at page 30. You'll see that at paragraph 8, the defendant states in his defense that Odyssey was under the control of the first defendant. And if we then fast forward to paragraph 66 of the defense, which is on page, page 41. And paragraph 49 is denied. Claimant has failed to identify any provision of the D2 indemnity agreement that was alleged to have been breached. Further, the second defendant was never a director of Odyssey. The true position is that Odyssey was at all material times under control of the first defendant, and the reference to paragraph 8. And just the responses to that in the reply, I can take you there, is on page 45. At paragraph 5, paragraph 8 is noted, and then at paragraph 35 on page 48, paragraph 35 says paragraph 66 is not admitted. Now, I don't know whether the court saw in its review of the papers that in the third witness statement of Mr. Dimitrakopoulos, in the table at paragraph 80 on page 74 of the bundle, that there's a suggestion. It's the second item, I suppose, not numbered, on that page, on page 74. There's a suggestion that in some way paragraph 66 of the defense suggests that there's an admission there. And in my client's witness statement, paragraph 34, which is at page 134, I'm sorry, I've gone to the wrong page. 143, excuse me, Judge. And paragraph 34, F, the suggestion that paragraph 66 of the defense implies an admission, plainly it does not. And this is one of the issues that the propositions that are included among the items that my client says need to be addressed. But I think that's the only admission alleged against me. And it is clearly something that has been fully joined on the pleadings. I then bring you to the second RFI, which is at page 368. And you'll see on that that we have the request of my client for information relating to paragraph 49. And there are detailed questions asked. And these are among the issues that have not been responded to. So I think it's quite telling, just having traced that through, that the short point, I suppose, is you might say, well, why did you bring me through all that? Isn't the short point that they allege that a breach solely on the basis that you're a director of Odyssey and you say you're not? And that is the short point. But when you look at the way that the pleadings have evolved in the first statement, it does seem as if responsibility for these events was first alleged to have originated with the first defendant. And the idea that so there's some responsibility on the side for this is solely linked to the suggestion that we're a director, which we say we're not. And Mr. Dimitrakopoulos' point, wider point, which he's urged on you multiple times today, is none of that matters because we're not talking about this. He even said this morning, the fact that the transaction documents, he said, first of all, he said there's no evidence that the transaction documents were not put into place, and that's incorrect. I'll give you the reference for that in a minute. But his wider point is the fact that the QNB loan agreement was going to be funded in a particular way, whatever the parties may have actually understood, and remember, these were business associates, all of them. And Mr. Dimitrakopoulos says, well, all of the background of their dealings and why they were putting this into place and why indeed would somebody in the position of my client sign up to such a wide-ranging indemnity unless he had an assurance which was understood on the basis of what he believed to be happening for the repayment of those loans. That's another question, which obviously suggests itself as something which this court would want to look into. I'll just give you the reference to the point on the evidence. Excuse me. It's page 132, and it's in the statement of my client at J and K of paragraph 7 of his witness statement, and I'll just let you read J and K. K in particular is the one in which he states that the
Yes, I've read those. Thank you.
Thank you. So the legal basis that we rely on for the existence of this, well, first of all, I should say, give you the other references in my client's witness statement. They're at page 136. Paragraphs, I've already, I'm sorry, excuse me, 132 is 7J, that's what we've just been on. And now I'm on 23D. Where Mr. Cameron says, at paragraph 72, Mr. Dimitrokopoulos states that there's no alternative version of events that could possibly exist to refute the validity of the indemnity agreement. But I say there most certainly is, and that the court must hear evidence and argument on my defences based on the failure of conditions and on the unenforceability and on the discharge of the indemnity agreement. And then going on page 138 to 139, Mr. Cameron points out that there are a number of factual areas relating to the surrounding circumstances of the funding of the QNB loan, and in particular at C, the representations made at the time of entering into the agreement, as well as the background facts and circumstances. If I could move to I have prepared, Justice Martin, a section on the RFIs. I don't know whether you want me to go through those.
Well, I don't know that we need to go through all of them, but if the point you want to make is made through a few illustrations, then perhaps that's the best way of doing it.
Thank you. I think I'll leave that because I think most of the arguments I was making were to illustrate the inadequacy and the blanket refusal character of our requests. I do make the submission based on the RFI itself. Second RFI is on page 366 to and up to 372. And you'll note on page 366
yes,
that the introductory paragraph points out that this is the second defendant's request to the claimant. And it repeats requests in the first one, to which it received a blanket refusal by letter dated 26 June 23. Now, the court will have seen in the skeleton argument to Mr. Dimitrakopoulos and in the third witness statement of sorry, I think it's the fourth witness statement of Mr. Dimitrakopoulos at 387 to 390. But effectively, these requests are being, first of all, rejected on what we say is a sort of bogus interpretation of the rules, that in some way we were stopped or prevented from making these requests. And secondly, as I've already said a number of times, on a simple blanket refusal to do so on grounds that our requests are irrelevant, but irrelevant on the claimant's case, irrelevant on the claimant's case, but arising from pleadings, we say that these are good requests and they require an answer. Just coming back then to the legal basis, why we say wider evidence. Well, legal basis for the points of defence relating to what I call the failure of the substratum. We have Article 1060 under Title 5, and we have Article 246 and 247 relating to the creation of conditions, including conditions precedent, which may be formed and form part of an agreement under UAE law, where the additional conditions are not expressly provided for in the written agreement. UAE law allows for them to be proven, and we say we must be allowed to prove those by evidence in this case. I wonder, would that be a moment to take a quick break?
Yes. How much longer do you think you might be, Mr. Ezelddine?
I don't think very long. Probably a half an hour.
Yes. All right. Well, let's break now for, shall we say, 10 minutes? Is that sufficient?
Yes. Thank you very much.
Yes. All right. Let's resume then at 5 past the hour, shall we?
Thank you.
Yes. All right. Thank you. Leave the lines open.
Yeah.
Just turn off microphones.
Yeah.
Yes, we're all resumed.
Thank you.
Yeah, Mr. Ezelddine, back to you.
Thank you very much, Justice Martin. I've reviewing notes and highlighting the particular points that I wish to address. There are 4 areas, and I'm going to start with just very briefly with the tripartite point, that we say we have an arguable case, more than arguable case, that this agreement, an indemnity agreement, is a contract of surety within the meaning of UAE, within the meaning of UAE law, in the same way as your lordship indicated his position in English law. And it's a question of the construction of the civil code, and including paragraphs, clauses or articles 1056 and 1057, which are the initial defining provisions for the application of Title 5 of the Civil Code. And very briefly, there's nothing in our respectful submission. Well, can you hear? Very good. I think you may be muted. Are you okay? I can't hear you now.
Yes, sorry. Yes, I can hear you fine. Thank you. Sorry.
I don't want to, unless the court wishes me to go into this in detail. Our case is that there is nothing explicit in the definitional provisions of the Title V that exclude indemnity agreements of this sort, which are, if I can call them, bilateral rather than trilateral. And no particular case has been advanced against us on that, but nonetheless, we say that it is, first of all, more than arguable that we are entitled to rely on all of these provisions, including 1092, and that we should be permitted to do so. The second area I want to bring you to is certain of the arguments set out in the skeleton argument of Mr. Dimitrakopoulos. I just find my page references. Page 615 to 616. And these are two illustrations of the incorrectness of the approach being taken by the claimant to this application. The first is under the heading mistake. And perhaps I could just ask the court to read paragraphs 99 to 105.
Yes. Yes, I've read those, thank you.
And if I could then ask the court, please, to go back to page 610. And
yes,
if you look, please, at paragraph 70, and I'll read this, the allegation that the transactional documents referred to in the indemnity agreement were not entered into is irrelevant. That was a submission that was made in terms again this morning, in view of the all-inclusive and sweeping wording of clause 9.1, and describing this as an encompassing event of a breach by the claimant of the QNB facility agreement or a breach of any of the other obligations. And then underneath that at 71, this is the allegation it contained in the defense, which is a specific allegation that the funds that were obtained from the QNB loan were not actually used for the purpose contemplated, and they went in a different direction. And it's my client's case that that in turn impacted the repayment capacity of the claimant, and that is connected, intimately connected with the breach that occurred here of the loan agreement. And then Mr. Dimitrakopoulos says in paragraph 71, these allegations not only disingenuous and incorrect, but also irrelevant in light of the clear wording of the indemnity agreement. And then he goes on. Well, that was it. And when one reads that with the previous one, which I think was paragraph 105 of which we've just opened, you see that this is an assertion that the central representations upon which we rely, the failure of the transaction documents, which we say is key to an overall assessment of what happened here and where liability lies, plus whether the transaction documents were entered into, are simply not issues worth exploring. And that's just based on Mr. Dimitrakopoulos' assertion that any evidence, and we say that that just simply is not a basis upon which this court could, in any comfortable way, proceed to immediate judgment against my client. In relation to the Papadopoulos case, while it was referenced there, it was a bit of an outlier case. You can see Justice Steele really going very far in looking into the question. I had some background involvement in that case. But first of all, the claimant actually was deceased. But more importantly, there was evidence in that case on both sides. And the evidence of the deceased was on a statement that had been made by him before he died. But there was the legal issue in that case that Justice Steele determined by way of the immediate judgment application was a Braganza type analysis. In other words, it was a strong standard or equivalent to a judicial review standard, and on the basis of the evidence, which included evidence on both sides, Mr. Justice Steele was content to grant immediate judgment in particular facts of that case. But it's interesting because if you go to the actual case, you'll see there's a case note at the outset of the judgment, and you'll see it's recorded there. I won't open it. You'll see it's recorded there that the underlying issue as to whether the claimant had an arguable case for an entitlement to a bonus outside the statutory scheme, in other words, as a purely discretionary entitlement, he had met the burden in terms of Part 24. So the underlying issue actually met the standard. It was only the Braganza, an analysis of the Braganza that led to the dismissal of the claim. So it is, as I say, it is a bit of an outlier. You don't usually find such detailed analysis in Part 24 claims, but one can do as the court well knows. But I make a general point on the law, and I appreciate that there isn't any mystery on any side about the law. But I do make the point that RDC 24 is a rule of law. It's a rule of law. It's not some discretionary maxim of fairness or some discretionary standard. And it's a rule of law for a very good reason, because it actually is designed to protect the rights of defense in particular, or the rights of any party, depending on who's bringing the application, to a fair hearing and determination of the case in accordance with the usual process of this court. So that's the second area. And then the third area is, excuse me, I'm a little bit snuffly, excuse me, the alteration of risk. Now, it is true that this hasn't really featured in terms of as an explicit part of pleading, but it is in the pleading, in that my client, and on the evidence of my client, is basically my client's evidence. The thrust of it is, I didn't sign up for this. This whole thing failed. And not only that, now there is a settlement which has removed a co-guarantor. And again, I come back to the point that under UAE law, we have a case that even though this is not a formal tripartite set of agreements involving a third party, nonetheless, it is in substance co-contracts of indemnity that were entered into, and the one, my client's indemnity agreement, was entered into on his understanding that there would be co-guarantors, not just the first defendant, but also Mr. Alamati. And neither, in the event now, we have an agreement which releases the first defendant from that co-guarantee in circumstances where the settlement agreement was arrived at on an agreed basis between the first defendant and the claimant that my client had fraudulently procured that agreement and provided it to the legal advisors of the claimant at the time. And that is an issue which obviously has to be explored in evidence and indeed by way of, we already have requests for information in relation to it, and potentially it may be a question of disclosure as well. But I think there's a point there that the normal comfort of a court faced with a claim or a defense by one, oh, I'm sorry, I've got a bleeding nose now, excuse me. Start again. The normal defense, or very often the comfort of the court in response to the defense of one guarantor that a co-guarantor should be on the hook as well, is to say, well, look, there's a valid agreement there. You can, if you are co-guarantors, you can claim that by way of subrogation. The court has already anticipated that, and we rely on that position. But in this case, that has been taken away from my client. And this assertion in Mr. Dimitrakopoulos' evidence, in inverted commas, that there has been no, sorry, it's in his, excuse me, I take that back, excuse me, it's in his skeleton argument, that there's been no alteration of the risk. That's just not true. Because there clearly has been, on my client's case, an alteration of the risk. And how could there not be? The agreement has been agreed between parties to it. An indemnity agreement is a contractual document. Doesn't exist outside the agreement of the parties. And therefore, if they've agreed that it's null and void ab initio, how can my client possibly have recourse against what we believed to be a co-guarantee that was in place? Now, the cases that I put forward to the court, and I do accept that they're put forward late, and they're English law cases, so they're not obviously core, but they're there, I hope, by way of assistance, just to illustrate this point on alteration of risk. And the first case is Beck Interiors. I'm afraid I don't have the reference pages to the new materials. And I'll just I don't propose to open it, or maybe I should, yes. It's a judgment of Justice Ramsey, Queen's Bench Division, 2009. Do you have that?
Yes, I do.
Thank you. And I make 2 points on this case. First of all, this is a very good illustration in English law how a contract of surety guarantee that the contents of that agreement can be proven as being wider than the express terms of the agreement. And that's what was in issue here. And secondly, it illustrates that where there's a conflict of evidence in relation to what the terms of that agreement were, in other words, what extrinsic oral or other communications there were between the parties that led to additional conditions and terms, where there's a conflict of evidence on that, that is not something that can be resolved, unsurprisingly, on a Part 24 application. And you'll find the reference, the relevant paragraphs at paragraph 37 through to 45 of the judgment internally. Perhaps if the court wishes to just peruse.
Yes, I'll have a quick look. Thank you.
37 to 45.
Yes, all right. Yes, I've read that. Thank you.
That case
point.
also does discuss back at paragraph 25 and following the so-called principle in Home and Brunskill, 1878, but I'll come to that in a minute. But obviously, I think the court really anticipated that in your reference to the subrogation and release implications of English law. And that's really why I included the commercial court judgment of Justice Cresswell, a longer judgment in Marubeni, Hong Kong and Mongolia. That, in particular, paragraphs 208 to 210, very succinctly identifies the principle that unless the court comes to the conclusion that the alteration in the risk is insubstantial or cannot be prejudicial to the surety is discharged from liability. And then the question whether an alteration is insubstantial or cannot be prejudicial to the surety is answered objectively. And then at 210, there's a sequence of cases illustrating it. And I think reading that judgment, it's striking how favorable the law is and in insisting upon the consent of co-sureties to alterations in risk. Now, it is the case here, and we don't have evidence to the contrary, although we have sought particulars on this. This is important to note, Justice Martin. Mr. Dimitrikopoulos makes the point, well, the facility was never actually restructured. And I just the reference in the pleading to that. Excuse me. I'll have to come back to you, Justice Martin. I'm sorry.
Yes.
There is a reference in the particulars of claim, amended particulars of claim, I believe, to say that it's here. I have it here. It's page 60. It's in Mr. Dimitrikopoulos' third witness statement. Page 60, paragraph 44.
Yes.
You see, on 17th of July 2019, QNB, excuse me, recorded by way of an offer to restructure the QNB facility agreement, which nevertheless never materialized. And then at page 117, which has been already opened to you this morning, you have that agreement, which we're told was never restructured. Now, I don't take the point on that because obviously, but I do point out by way of observation that obviously if the agreement had been restructured, that would be ground upon which, on the basis of the principles identified, equivalent principles in UAE law, we would argue, we would be discharged because the loan facility had been restructured without our consent. But that obviously didn't happen. But what did happen, that there was a fundamental alteration of the risk that we now face by reason of the release of the D1. And that ties back into our mistake, the misrepresentations, the other conditions that we say existed, all under various provisions of the code, that there was also going to be another guarantee from Mr. ALMHEIRI, which was never entered into. So that's the reason why I included that particular case as an illustration of English law, and we would respectfully wish to advance the equivalent argument, which is of course a relatively complex argument, by reference to the equivalent surety principles and case law of the UAE courts. The fourth area then that I wanted to finally address you on are, excuse me, yes, points of rebuttal just arising from this morning. If I could just ask you to turn to page 135. Um, 23B. This is my client's evidence in relation to the benefit. And it appeared to me that Mr. Dimitrakopoulos was contending that just purely on the basis of the contractual provisions in the agreement, that it just simply isn't open to my client to point out that there may have been people other than my client who benefited from this. Now, as I said, these people were all business associates. There is a context for this agreement, and the court, I am sure.
Why would it matter? Why would it matter if other people benefited from it?
I don't think it. Well, I think the point is that my client has reacted to this, and is it because the suggestion has been made against him? Oh, look, you went. This was purely for your benefit. So as a factual matter, he's human, and he's saying.
Yeah, but the question that I've got to determine is whether there is a real prospect of a successful defence.
Yes.
And so I just don't see how the question of who got what benefits from the transaction really matters.
Yeah, I don't disagree, but I think there seems to be an issue on this, and I think one of the reasons is because it's being suggested that it's weigh very heavily in the balance for, in colloquial terms, why my client should be stuck with the agreement. And that's what he's reacting to, is to say, hold on a second, there's a wider context here, and I'm respectfully suggesting that the court will want to know and hear evidence of what that context is. A lot has been said about the delayed reaction of my client, failure to respond to the notice. But the court will notice that there was only 2.5 months between the demand and the issue of proceedings. And there's just a huge amount of outrage being expressed about and disbelief and inferences being asked to be drawn from the failure of my client, or which, in respect of which there is no evidence. I'll come to that in a minute. But literally, it was only 2.5 months. But also, given that it has been asserted by Mr. Dimitrakopoulos as a fact, we have taken instructions, and on the basis of those instructions, I can tell the court that the position being asserted that there was no response is incorrect on the basis of our instructions, and that will be demonstrated on the evidence on our side in due course. A general point, there was a suggestion that the risk environment which preceded the agreement should be taken into account. But there's no recognition equally that the actual risk should not be delved into. And that's a contradiction. The specific risk that my client was underwriting, if you like, should not, that in some way, that should not be delved into, whereas the risk environment. And that argument as to risk environment I've already addressed, because that was relevant to the point of whether there had been an alteration of risk. If I could ask the court please to turn to page 573. Here is at paragraph 121 of Ms. Lester's witness statement. An enumeration in more detail than is provided for in other documents on behalf of my client as to what the relevance of the various witnesses is and what how their evidence will likely assist or potentially assist. And that related, I think, to the point being made in relation to page 146. On the second last point, then, the whole area of nullity in arising from 243 and 246, excuse me, I freely admit is a new subcategory of nullity, and I've indicated in the skeleton that potentially it might be an issue that we may need to seek to amend if our defence in due course seek permission to amend. Just for reference, you'll see on page 832 of that, which is our skeleton. That paragraph 13 is paragraph 13 is the relevant paragraph, and read together with 7 and 8, or footnotes 7 and 8, we have provided an indication of the primary legal basis 207, but it's also actually 243 and 246, plus certain cases indicating, as we said in the footnote, that what happens here is that the tort provisions, and I'm summarising, and I can take you there if you wish, but I can tell the court that the principle is that, of course, first point, freedom of contract provided for in the Civil Code. Therefore, you can provide in a contract for anything, but you cannot provide for prejudice resulting to the other side in a contract, even if it's specific, where that prejudice it results from intentional, deliberate, or otherwise unlawful conduct. We say it's arguable that what we have here is, in terms, an open-ended agreement to indemnify the claimant for his own failure to respect the loan agreement. Now, it's one thing to say that's just a failure, you didn't pay the money. But it's on our case, as we're getting to, or where we're exploring, and where the evidence hopefully, on our case, will stack up once we have disclosure, etc. is that the wrongdoing that we assert isn't just a failure to have repaid the loan, but it's through the claimants and others' actions that the repayment system, the repayment mechanism was sabotaged. And we say that that, not just as a question of the nullity of the agreement, that's one aspect. More fundamentally, the claim advanced on the facts is one that is tainted in this manner, because it is one where the deliberate conduct of the claimant, on our case, in sabotaging the loan repayment mechanism, which was the substratum of the agreement, came about through its deliberate. I think those are the points, Justice Martin, unless you have.
No, I don't. Thank you, Mr. Delmalane. Mr. Dimitrakopoulos, do you have any submissions in reply? Mr. Dimitrakopoulos?
Apologies, Your Honour. I was trying to find the unmute button in this new system. I found it.
Good.
So,
Good.
yes, let me try not to repeat myself, of course. I've had a look at my notes. I think there is an attempt to conflate indemnities and guarantees. We have an indemnity here. So the whole purpose is compensate me for any loss I have incurred as a result of something that I've entered into for your benefit. It's not a guarantee to replenish, to pay the creditor. So it's not another way for the creditor to obtain the money. So there's no authority that's been brought to you as far as UAE law is concerned that the two are one and the same. We have referred to authority that sets out, this is the Dubai court judgments I referred to you, which also sets out that the time bar defense can be contracted out of, and sets out the system and the circumstances under which those provisions of the law apply. It will be the classic guarantee. So we disagree that our situation here amounts to a guarantee. With regard to the RFIs, now, if Your Honour has had a look at them, they are essentially a request, or 39 requests actually, addressed to the claimant by the defendant. Give us the ammunition to support our defense. They're not documents that would fall more properly under the request to produce. They're documents that, first of all, are aimed towards substantiating the defense of the defendant, and secondly, they all have invested very heavily on the history behind and before the indemnity agreement, which we say is irrelevant in the context of the clear wording of the indemnity agreement. Anything that was relevant to the indemnity agreement, we have provided. And this, of course, relates to the demand from Q&B, the dishonored checks, the order that we have been faced with by the Dubai courts, and the travel ban. We provided those. One unreasonable request was to provide an original certified copy of those, which we did not provide, but we find that as unnecessary. Now, if you just bear with me, Your Honour. It was also suggested that the Christos Papadopoulos case was a sort of fringe case. Well, it does set out that in the contents of an application for an immediate judgment, the assertions made in a witness statement shouldn't be taken at face value. And here we have a witness who, yes, has produced a witness statement, but has stated in it that this was not for my benefit, the indemnity agreement. He said it clearly, and I've taken Your Honour to the specific paragraph. What my learned friend said, that it was for the benefit of others as well. Your Honour pointed out that there's no really any relevance or questioned whether there's any relevance as to whose benefit is it for. But the point I'm making is that we have a witness who blatantly testifies that it was not for his benefit, not that it was for the benefit of others, that it wasn't for his benefit when the indemnity agreement itself says in black and white, it's for your benefit. So in that context, the Christos Papadopoulos case that says you don't have to take anything that is said in a witness statement at face value becomes relevant. Now, I would say, if I could be pardoned for saying that it is a fantastical suggestion to say that the restructuring didn't take place, but had it taken place, all things would be different. The long and the short of it is that it did not take place, so that's neither here or there. It doesn't take the defendant's case any further. It's an irrelevant point. And finally, all this condition and assumption that the settlement agreement was somehow something that changed anything, we have taken Your Honour to the environment. There is the risk environment that was undertaken by the defendant. Nothing has changed. He is in exactly the same position as he would have been had there not been a settlement agreement. There was some reference to the delay in responding to our demand. We don't consider that to be a pivotal issue in our application. We just pointed out in the sense that, there's a lot that has been said in his defense that could have been uttered earlier. So I don't think that any major issue has been raised by learned friend that I need to focus further on. I think, unless Your Honour has any specific questions to me.
No, I don't thank you, Mr. Dimitrakopoulos. I'm very sorry for mangling your name, but there we go.
Right.
All right, gentlemen. I've come. Yes.
Excuse me, Justice Smith. It's something which I can't leave out, and if I could beg the court's permission.
Yes. Yes. All right. Mr. Dimitrakopoulos, I'll give you an opportunity to reply.
Of course, yes. And I'm very grateful. Thank you to my friend. It relates to the carve-out point, whether the contracts carve out. Obviously, you will have probably already seen the clause 2.3 of the agreement is not in any way an explicit carve-out from the law. It just says that a notice can be given at any time. And in that regard, if I could ask you please to turn to page 943. This is a judgment of the Dubai Court of Cassation, which begins on the previous page, the English language version. And I'm relying on the second paragraph. It is established by this court that even if the rule provided by Article 1092 of Civil Code is not related to public order, whereas the guarantor may consent to continue securing the secured debt for more than 6 months. However, his consent must be conclusive, explicit, and undoubted. And we say that that is not the case for clause 2.3.
Mr. Dimitrakopoulos, reply.
Yes, Your Honour, I think I've taken you to the specific provision that in the indemnity agreement that says in and at any time. That, to my mind, in any version of the English language, is conclusive, explicit, and undoubted. Both parties have agreed to it. I don't think that there is a suggestion that they need to refer to Article 1092 and refer to the 6-month period and say that we are contracting out of that, as long as they use words that clearly amend that provision, there can be no question that they have conclusively and explicitly changed that provision.
Thank you. All right, well, thank you, gentlemen. I've come to a view, and I'll give short reasons for the view to which I've come now. So just bear with me. The claimant has applied for immediate judgment pursuant to Part 24 of the Rules of Court. The question which must be addressed by the court in dealing with applications of this kind is not contentious and has been referred to in many cases. The question really is whether, on reviewing the materials as a whole, the court is satisfied that the defendant has a realistic prospect of success as opposed to a fanciful prospect of success. And a realistic prospect of success is one that carries some degree of conviction, is not one that is merely arguable. Now, in the circumstances of this case, no evidence has been adduced from the claimant in support of his claim. It is true that the claimant has produced a witness statement which is on the file of the court, but that witness statement related to an earlier issue and only deals with the question of the terms upon which the claim was settled against a person, Mr. Araj, who was previously the first defendant. The evidence doesn't appear to be relied upon in support of this application. The evidence that has been filed with the court in support of this application comes entirely from the claimant's lawyer, who of course has no direct knowledge of the facts. And that evidence obviously would be inadmissible at trial. So the particular circumstances of this case, the question is whether the case for judgment has been made out on the basis of admissions, either to the pleadings or elsewhere, by the defendant, or alternatively documents that are not contentious. On the other hand, the defendant has filed a witness statement, and parties have disagreed as to the extent, the weight the court should place upon that witness statement. I accept that there are cases in which evidence adduced in opposition to an application for immediate judgment can be given little or no weight on the basis that the evidence is inherently implausible or inconsistent with non-contentious facts or documents. But in my view, this is not such a case. The evidence that has been given by Mr. Cameron is not directly contested. The claimant, on the other hand, submits that because that evidence is in some respects different to the precise terms of the agreement upon which the claimant relies, the evidence should be discounted and it should be concluded that the facts asserted by the claimant did not occur. It seems to me that submissions of that kind are preeminently matters for trial, because they turn upon the credibility of a witness, in which event, of course, the trial court is in a much better position to assess credibility than a court hearing an application for immediate judgment solely on the papers. Much of the claimant's argument in support of the application depends fundamentally on the proposition that the court can't look beyond the four corners of the indemnity agreement to ascertain whether the defendant has a defence. Perhaps that is a proposition that might be established at trial after all the evidence is in, but it's not sufficiently self-evident, in my view, to sustain a judgment without a trial. The defendant raises many matters and many types and kinds of defence in opposition to the application, and as usual in cases of this kind, some at first sight appear to be stronger than others. In the circumstances of this case, it's unnecessary for me to go through them all, because I'm satisfied that at least some of the grounds of defence relied upon by the defendant make it necessary that there be a trial in the interests of justice. The following matters are sufficient to explain why I've come to that conclusion. Firstly, the defendant alleges that misrepresentations were made by an agent of the claimant prior to his entry into the indemnity agreement with respect to a number of matters, including firstly, proposed restructure of the HSBC loans. Secondly, the servicing of the debt that was to be incurred through Qatar National Bank by the purchase of assets and the lease back of assets to the claimant or his special purpose vehicles. And thirdly, the representation that at least one person other than the person who was previously the first defendant, that is Mr. Araj, that is, I think, a Mr. ALMHEIRI, that is a person of financial substance, would be also providing an indemnity. Now, Mr. Cameron asserts that these representations were false. Now, if that assertion is made out on the evidence, in my view, a real question would arise as to the impact of those representations upon the indemnity agreement under the provisions of the law of the I don't accept the claimant's submission that the issues can be answered entirely by the terms of the document itself. It seems to me that there are questions of fact that must be investigated and determined after a trial before the impact of those allegations under UAE law can be assessed. The second matter that I think must be further investigated concerns the terms of the settlement between the claimant and indeed the effect of the settlement between the claimant and Mr. Araj, who was previously the first defendant in these proceedings. On the evidence before me, there are some very curious aspects of the terms of the settlement relating to the promise of provision of assistance by Mr. Araj in making good serious allegations against the defendant, and those matters could merit investigation at trial. However, I think it's sufficient for present purposes to note that it's undoubted that the claimant has surrendered a claim against Mr. Araj, who granted an indemnity in virtually identical terms to that granted by the defendant. The claimant has surrendered that claim in return for a promise to pay over an extended period, an amount which is much less than the amount which is claimed against the current defendant. That seems to me to raise a real issue as to whether, under the law of the UAE, a party indemnified by more than one party can release or partly release one of those parties on favourable terms without affecting that party's rights against the remaining indemnifier. Now, I don't know what the answer to that question is, and I'm not sufficiently satisfied on the material before me that I know what the answer to that question is, or that it is independent of the facts that might give rise to the question. Third point is that many questions of UAE law have been raised by way of defence. The fact that the law is the law of the UAE is not of itself significant in determining an application for immediate judgment. And if the legal issues that were raised were entirely, could be entirely determined without reference to the facts, then the fact that it's the law of the UAE instead of the law of the DIFC or of the law of England would make no difference, because this court is, after all, an international commercial court, and issues of law from whatever legal system the parties have chosen to adopt can be determined by the court. The critical question is not so much that the relevant laws are the laws of the UAE, but the question is whether the resolution of those issues of law turns upon facts which are contentious. Now, without going through the issues of law that are raised, I'm not presently satisfied that those issues can be resolved without reference to facts that are contentious. And it seems to me in those circumstances that it would be dangerous to rule at this stage of the proceedings that those contentious facts are irrelevant, but rather it seems to me that the interests of justice favour adopting the usual course of hearing the evidence and then getting the full benefit of argument on the issues of law in the light of the potential findings of fact that are open on the evidence. So for all those reasons, in my view, there is a real prospect that a defence may be established after a trial, and that prospect is real and not fanciful and is more than merely arguable. So for those reasons, I think the application for immediate judgment must be dismissed. Mr. Dillon Malone, what do you say about costs? Can't hear you. I think you're still on mute, Mr. Dillon Malone.
Excuse me. There are no statements of costs before the court, Justice
Yes.
Martin, and in those circumstances, it's not open to me to apply for a summary assessment today. I understand that that rule is strict.
Yes.
Unless the court would allow some time to.
No, I think in the section you moved for an order for costs.
Oh, my application, of course, is for costs.
Yes. Well. Then I think, subject to anything Mr. Dimitrakopoulos might say, I think the order should be for costs to be assessed unless agreed. Mr. Dimitrakopoulos, do you have anything to say about that?
I was wondering if one thing to consider is whether some time has been saved on certain issues through this process, so that costs would be in the case and finally on trial, as opposed to be determined for the specific application.
Mr. Dillon Malone, in reply.
Well, it seems to me that this is classically a case where the attempted shorter route has resulted in a longer route. To the extent that we've had the benefit of exploring the legal issues, that is a natural byproduct of contested application, and in my respect, this is not a reason to depart from the ordinary rule.
Yes. Yes, I agree. I think this has been a distraction, unfortunately. I can understand why the application was made, but it has failed. There's no reason why costs shouldn't follow the event. So the order will be that the claimant will pay the defendant's costs of the application to be assessed by a registrar of the court if not agreed.
I'm very sorry to interrupt, Justice Martin. It was at the very end of our skeleton argument. The court will recall that it was on the eve of the CMC
Yes.
that this application was filed, and the Justice ALMHEIRI, I believe, reserved the question of the costs of the CMC, and on my application, I ought to have said is to include also the wasted costs of the CMC.
Well, why were those costs thrown? What happened at the CMC?
Well,
orders were made, weren't they?
Yeah, well, yes, they were, but yeah, that's correct. Yeah.
Well, I think the CMC served some utility. I don't think I should go beyond it. If you want to, if they're reserved, you can go back to the judges, go back to Justice ALMHEIRI, and she might be able to do something.
Thank you.
All right. Well, unless there's no, that's all right. Unless there's anything else, those will be the orders. And I'm grateful to both counsel for their assistance and for the argument that's been developed. Thank you both, gentlemen. Unless there's anything else, court will now adjourn.
Thank you very much.
Court's adjourned. Thank you.